Case number 22 CR 18, State Highway versus David Lanigan. Appearing on behalf of the State's Assistant Prosecutor King, appearing on behalf of the Defendant's Attorney Douglas Bradden, here, David Lanigan.
Yes, I am.
Mr. Lanigan has been indicted for trafficking in cocaine, possession of cocaine, with burglary felonies. This matter is set for a pretrial today. I believe the final of the trial is set for April the 14th. The courts received a plea form here, Mr. Lanigan, that says you're going to throw your not guilty, plead guilty to count 1. This is a 3-page document the prosecutor's office prepared from a template to have a computer and put in the information relevant to your case. On page 3, there are signature lines. There's a sentence about halfway down that reads, "I entered this plea voluntarily," and then immediately below that there's a line under which the signature defendant appears to be D. Lanigan. Is that David Lanigan?
Yes,
Did I read it? Okay. And this is your signature I'm looking at then. When did you sign this document?
You can tell him.
When did you sign this document?
He's asking you, when did you sign this plea agreement?
Oh, 10 minutes ago.
Okay. And were you with your attorney who went over with you before you signed it?
I read the whole thing.
Okay. And he explained everything to you?
Right.
Okay. Now, Mr. Lanigan, had you been discussing this possibility with your attorney about a possible plea agreement before you came here today?
Yes.
And is this something that you thought might happen today?
I wasn't sure.
Okay. Do you feel that you've had enough time to fully consider this matter before making a decision to sign this document?
No.
You don't think you've had enough time?
Do you understand what he's asking you?
What I'm asking is,
He's asking you if you've had enough time to consider the agreement that we've discussed.
Yes, I have.
okay, you don't feel you've been rushed or pressured into doing this today? Okay. So you're comfortable going forward with it?
Yes, I have.
And did you enter into this agreement to plead guilty voluntarily?
Yes,
All right. Now, on page 1, it states that you're going to withdraw your not guilty plea, plead guilty to the charge of count 1, trafficking cocaine under section 2925.03A2, a third-degree felony. It further states that you understand that the potential maximum penalty for the offense is up to 36 months in prison. Minimum if one prison term imposed is 9 months. And there's different increments in between those two ranges. There's a fine available of up to $10,000. There's a mandatory fine of $5,000. There's a possible license suspension of 6 months to 5 years. And now under the law, this is not a mandatory prison offense. It's presumed there should be a prison term imposed. What that means is that the legislature said that in their view, this type of offense ought to be a prison term, but it's still up to the judge. I don't have to do that. I can give you community control. You understand that? Are you facing any felony charges in any other jurisdiction?
No.
Are you currently on community control, probation, parole, or post-release control for a felony?
I'm on probation, but not felony.
Okay, but not for a felony. Okay. Now, under the law, Mr. Lanigan, should you be convicted of this offense and should you be sentenced to a prison term, once you complete that prison term, the law provides that the adult parole authority has the option, if they choose to exercise it, to put you under what's called post-release control supervision for a period of up to 2 years after you have completed your prison term. So you'll be supervised under the terms they set. The court's not involved with that. In the event that they decide you should be under that supervision and impose conditions on you and you fail to comply with those conditions, then they can return you to prison for failing to comply with those conditions, even though you serve the entire term that's set by the court, for an additional period of up to 9 months for any single violation. But there is a cap or limit of half of whatever prison term was imposed and served for all violations. But should you be convicted of a new felony while under post-release control supervision, then in addition to whatever sentence the judge in the new case could impose upon you, that judge could also sentence you to an additional term of incarceration for committing that to a felony while under post-release control, in this case, to 1 year or whatever time is left on the post-release control period, whichever is greater. And if that occurs, that sentence would have to be served consecutively to the sentence in the new case. Do you understand that? Yeah, speak up. Do you understand what I just said?
Well, it's kinda like, I understand what you're saying, but it ain't never gonna happen, I'll never get company in there.
Okay, but yeah, well, I hope that's true, but the only thing I'm explaining to you is, I need to know is, do you understand what would happen if that occurred? Okay. Now, under the laws I indicated, I'm not required to sentence you to prison, although there's a presumption. And so what that means is that the court could decide, rather than to sentence you to prison, to put you under community control sanctions. And community control is a term we use now for probation. So what that means is that you would be supervised under the conditions as set by the court for a period of up to 5 years by a county probation department officer. And if during that time the probation officer felt that you were not complying, then they would have to file a written notice of that with the court. A copy would be served on you. You would have a hearing and be entitled to be represented by an attorney. If the outcome of that hearing was that you failed to comply, then at that time the court could revoke your community control and sentence you to up to 36 months in prison and fine you up to $10,000. Do you understand that? Right now, the charge in this case in count 1 reads that on or about May 8, 2021 in Highland County, Ohio, you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute cocaine, a Schedule II controlled substance, an amount equal to or exceeding 10 grams but less than 20 grams, when you knew or had reasonable cause to believe cocaine was intended for sale or resale by the offender, that's you, or another person, in violation of section 2925.03A2. That's the charge that we're looking at here in the indictment, trafficking cocaine, a third-degree felony. Now, Mr. Lennigan, do you understand what it is the state has accused you of having done, when, where, and how they alleged you did it?
I think so.
Okay, do you need to speak with your attorney about that?
Yeah, we have a discussion.
Okay, well, what I'm saying is, I need to know if you understand what it is you're pleading guilty to. In other words, what are the acts that they accused you of having done? Are you?
I do understand what
you understand that? Okay. Now, have you discussed the nature of the charge, the evidence of the case, possible legal issues of the case, possible offenses you can try to raise at a trial, and the possible outcomes of a trial with your attorney?
Yes,
and are you satisfied with his advice and confidence in this matter?
Yes, that's my attorney.
Okay. Are you under the influence of any types of drugs or alcohol at this time?
No.
Do you take any prescription drugs?
Yes.
Do any of them interfere with your ability to understand what's going on or to express your thoughts clearly? Okay. Has anyone threatened you to make you plead guilty here today?
Nobody.
Now, on page 2, toward the bottom of the page, there are a couple of lines that are printed in bold and underlined. So I'll read those as follows. Defendant shall enter a plea of guilty to count 1. State will dismiss count 2. State defense jointly recommend community control and substance abuse treatment. Is that your understanding of the agreement?
Yes.
Has anyone promised you anything other than that to get you to plead guilty here today?
No.
Now, Mr. Lanigan, under the law, the matter of sentence is up to the judge. So even though your attorney, and the prosecutor's office are saying to the court that you should get community control with substance abuse treatment, not required to follow that recommendation. So if you plead guilty, once I've considered all the information that's submitted to me, if I decide that's not the appropriate sentence, I could impose a prison term of between 9 and 36 months in the increments provided by law, fine you up to $10,000, and suspend your license for 6 months to 5 years. Do you understand that?
Yes, my boy does like that.
Now, Mr. Lanigan, do you hold any license or certification from any state governmental agency that regulates any profession or occupation?
I'm sorry,
Do you have any certificate or license from a state regulatory agency, a governmental agency, that regulates professions like nursing or barbering or something like that?
Not right now.
Okay. Now, you have constitutional rights to understand, Mr. Lanigan, before I can accept the plea of guilty from you. First of all, you have a right to have your counsel in the Constitution, and Mr. Brennan has been employed by you. Now, in the event that you were not able to continue to pay him, court would appoint counsel for you to represent you, make sure you were represented. So the reason I say that is my question is to you is, are you entering into this plea agreement because you are concerned about being able to pay for an attorney to continue to represent you in this matter? Okay. All right, now under the Constitution, you have a right to have a jury trial in this matter, Mr. Lanigan, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. Now, after 12 people would be selected, that would be the number of jurors, the evidence would be presented, they'd be instructed on the law. Then that jury would have to decide by unanimous verdict, in other words, all 12 would have to agree as to whether or not the state proved your guilt. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you can waive in writing, and waive in this context means to give up your right to have a jury trial. And then in that event, you would have what's called a court or bench trial, which means that it would be the judge instead of a jury who would hear the evidence, apply the law, and decide whether or not the state proved your guilt of the charge. Do you understand that? Now, under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in public in front of you, your attorney, the jury, and anyone else that's here. After the prosecutor's done asking those witnesses questions, your attorney can ask questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that helps your side of the case. You understand that? All right, Mr. Lanigan, under the Constitution, you have a right to use the power of the court to compel or force witnesses to be here at the trial, testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order. It's called subpoena. And that subpoena will force those people to come to court to be able to testify if you wanted them to, even though they didn't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that? Right now, under the Constitution, Mr. Lanigan, you have a privilege against self-incrimination. What that means is that you can't be forced to give evidence or testimony against yourself at any time in these proceedings. So no one can ever make you testify. The prosecutor can't, the judge can't. You decide. If you decide you're not going to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. And in fact, no one's even allowed to talk about it during the proceedings with one exception, and that is if there's a jury trial and you do not testify, then the judge instructs the jury that because that is your constitutional right, they cannot consider it for any purpose. Do you understand that? All right, Mr. Lanigan, under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense by proof beyond a reasonable doubt. What that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence in your own defense at trial. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state, the prosecutor, to prove your guilt on every essential element of the offense by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. You understand that? Right, now originally you entered a plea not guilty to the charge, Mr. Lanigan. The not guilty plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've just explained here this afternoon. Now, if you change your plea from not guilty to guilty to count one, that is the complete opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that it's a crime, and that you're the one that committed that crime. That plea waives, gives up all of the rights that I've just described, except for one, your right to have an attorney. You always have a right to have an attorney no matter what you plead. But with that exception, your plea of guilty waives, gives up your right to a jury or court trial. Waives, gives up the right to confront witnesses and cross-examine through your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses to be in court to testify for you, just like the state. Waives, gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It waives, gives up your right to require the state to prove your guilt by proof beyond reasonable doubt, because if you say you're guilty, then the state doesn't have to prove you guilty. Plea of guilty also waives, gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if I were to sentence you to the maximum sentence or under certain limited circumstances, you could file an appeal. That appeal would have to be filed within 30 days of your sentencing entry being filed in the case. And finally, a plea of guilty does subject you to being sentenced immediately by the court. Now, do you understand all of those things, Mr. Lanigan? And are you a U.S. citizen?
Yeah.
And do you have any questions about the charge or the possible penalties?
No.
You understand? You understand?
Yeah, but
You have any questions about the plea agreement?
No.
You understand?
Mhm.
You have any questions about the constitutional rights I've explained to you? You understand those? You have any questions about the plea of guilty, what it means, what the consequences of that would be if you enter that plea here today?
Yes.
Do you have any questions first? Now do you understand?
I didn't do that.
Now you do understand then the consequences?
Yeah, but
Okay. Is there anything else you'd like to speak to your attorney about before we go any further? If you have any questions about anything I've explained to you here today?
you explained everything to me.
Is it your decision then to withdraw your not guilty plea and plead guilty to count one according to the terms of this plea agreement that we've just gone over? Okay, then as to the charge which alleges that on or about May 8, 2021 in Highland County, Ohio, you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute cocaine, a Schedule II controlled substance, an amount equal to or exceeding 10 grams, less than 20 grams, when David A. Lanigan knew or had reasonable cause to believe the cocaine was intended for sale or resale by the offender or another person. Violation of section 2925.03A2, charge of trafficking cocaine, a third-degree felony, carrying a possible prison term of between 9 and 36 months in increments provided by law, a fine of up to $10,000, a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, thank you. Court finds that on this day, in open court, defendant was advised of all his constitutional rights and made a knowing and intelligent and voluntary waiver of the same pursuant to Criminal Rule 11. Plea is accepted and ordered filed. Defendant is found guilty of count 1, count 2 is dismissed. Court refers the matter to the probation department for a pre-sentence investigation, which will include an assessment for substance use disorder and/or mental health issues and recommendations. And the matter will be set for sentencing. Today is the 5th. What's your schedule look like on the 4th in the morning, Mr. Grant?
May 4th, Your Honor?
Yeah.
If we have a winner on May 4th, Your Honor,
Okay, at 9 o'clock?
we can do that.
All right. So your sentencing will be May 4 at 9 a.m. Now, you have an appointment to see the probation department today?
Right after.
Okay, I was going to say, if you don't, once you go down there and make one, tell them that you've entered plea of guilty, that you need to have a pre-sentence report. And that'll be a different officer than you see, probably Mr. Fulton. And then he'll set up an interview for you and prepare a report. Are you currently in any kind of a treatment program?
I've been going inside of the paint and going to report out they take my insurance.
Okay.
I got a letter from them.
All right. Okay, is that for mental health or substance abuse or both?
Mental health.
Okay. All right, well, there'll also be an assessment for the substance abuse disorder too, because those things commonly occur together, so. All right, so you go report down to the probation department, and the bailiff here is going to give you an assignment notice so to remind you of your next hearing date. Is there anything further, counsel?
No, Your Honor.
All right,